Mr Deputy Speaker, how would any of us feel if our 27-year-old son was king-hit and struck from behind to the back of the neck and head and hit the ground dead? For his attackers to spend only 18 months in prison, and for their names to never be printed, for a death certificate 3 years later to not be issued, for no coroner's inquest to be held, and for charges of murder to be downgraded to manslaughter, and for charges of aggravated robbery to be downgraded to stealing. This, Mr Deputy Speaker, is exactly the situation that Mrs Lavinia Dingle finds herself in today. I contacted her for no other reason in January, February of 2010 to simply express to her my great sadness and sorrow on behalf of the community that I represent for what had happened when her son had innocently travelled to Tasmania for work and did not return home alive. The purpose for me rising tonight is to place on record a number of statements from the mother in her correspondence with the Attorney-General. This woman is deeply dissatisfied with the justice system in Tasmania, and she wants answers. She has sought answers, and those answers have not been forthcoming and don't go anywhere near to satisfying her concerns. I don't know if the time tonight will permit me to get through all of it, but I will try. On the 27th of August, Mrs Dingle wrote, "Dear Mr Whiteman, I've been advised by Coroner Timothy Hill that he has written to you advising that he has decided that there is insufficient cause to resume the inquest into the murder of my son Simon Dingle. I have it on good authority that there was sufficient evidence to charge the perpetrators of my son's murder with aggravated robbery, as they premeditatedly conspired to bash and rob my son, and I believe there is evidence of this in the police file. For some inexplicable reason, the DPP downgraded the charge to manslaughter and stealing, and I want to know why. I have requested a copy of the police file, as has Michael Ferguson and Vanessa Goodwin on my behalf, and to date we are still waiting 2.5 years after my son's death. I realise that I'm making a serious allegation and that an investigation may not alter the outcome, but I'm not seeking revenge, only justice. If the charge of murder and aggravated robbery was downgraded erroneously, I want this to be made public. It's my wish that no other family go through what I and my family are going through and will go through for the rest of our lives. The loss of a son, brother, nephew, cousin. The perpetrators of my son's murder got off virtually scot-free. This is not right, and someone needs to take a stand and correct the wrong. I know one-punch kills crimes are escalating, and Australians are fed up with the lenient sentences and the message that this is sending. You may not be aware, but my son did not die from injuries sustained from the fall after he was punched, but from the blow itself. It was meant to cause as much damage as possible. They were out to get him. These offenders deserve to be incarcerated for many years, and this sort of sentence would act as a deterrent, not the slap on the wrist that the offenders received in my son's case. While I appreciate that you cannot become involved in every case, I would appreciate your interest in this case and look forward to hearing from you at your earliest convenience. A grieving mother, Lavinia Dingle." Mrs Dingle had to write back to the Attorney-General on the 8th of October asking for why she hadn't yet received a reply. Eventually, 12 weeks after the initial correspondence, the Attorney-General wrote back on 19 November, providing her with none of the sorts of reassurances that she was seeking. Additionally, I then contacted Mrs Dingle and asked her, well, in the context of all of this, what would you say back to the Attorney-General? And I've made the decision to place it on the record in this House, because I do agree with Mrs Dingle that there needs to be more light shone on this case, because justice not just must be done, it must be seen to be done. Dear Michael, this is what I would say to the Attorney-General. Thank you, Mr Whiteman, for your letter of 19 November in reply to my communication of the 27th of August. It's been almost 3 years since my son was murdered in Deloraine, and I do not believe justice has been done. I dispute the Director of Public Prosecution's decision to downgrade the murder of my son to manslaughter and stealing. I have it on good authority that there was sufficient evidence to prove that the offenders conspired together before the event and therefore premeditatedly attacked and robbed my son. The cowardly blow to the back of my son's head was so severe that it severed his subarachnoid artery and he was dead before he hit the ground. This offence should therefore be considered aggravated robbery, carrying a far more serious sentence. The offender spent 18 months in a juvenile detention centre while I and my family are serving a life sentence. I find it incredible that you are not in a position to investigate the decisions of the coroner or the Director of Public Prosecutions because they are independent statutory officers. Somebody must have the power to ensure that these officers are accountable for their actions, and this is the person with whom I wish to discuss my concerns. The now Premier did offer to talk to me at the time, but nothing came of this. And I briefly depart and cite Examiner, 17 January 2011, headline, Giddings to meet Dingle. In the meantime, I'm unable to access the police file under freedom of information, and I'm unable to finalise my son's estate as I do not have a death certificate. I am not seeking compensation or a retrial. All I'm seeking is to put right a wrong. I suspect I'm not the only grieving mother who is disappointed in and believes she has been let down by the system, and if I can bring about accountability and an apology for an erroneous decision, then I will gain some satisfaction, and my son's death will not have been entirely in vain. Kind regards, Vinnie. Tonight, Mr Deputy Speaker, in the 35 seconds I have remaining, I simply call on one, the Premier, to make good on her promise to meet Mrs Dingle. Approaching 2 years later, that meeting has still not occurred. It ought to happen. Secondly, I call on the Attorney-General to enter this Parliament and make a statement to the Parliament explaining 4 things. Number 1, why the charges were downgraded from murder to manslaughter and from aggravated robbery to stealing. Second, to explain to Parliament why after nearly 3 years there's still no release of that police file. 3, why there is still no death certificate for the family. And 4, why there was no coronial inquest. These are questions that demand answers. Justice must not just be done, but be seen to be done.